When we talk about estate planning, what are we talking about? What is an estate?
An estate involves everything that you own. Could be both movable or immovable property. So think about your land, your cars. If it's a company, think about the shares that you own.
There's this perception that with writing succession planning, estate planning is for white collar jobs. Is that true?
Absolutely not.
Not.
You know, your M-Pesa account is an asset. You know, your M-Shwari.
Yeah.
Similarly, your Fuliza is an asset. You have your list of assets, you have your list of liabilities.
Yes.
Anything is an asset. Anything and everything is an asset. As long as, think of it this way, if you did not come to this planet with it, it's an asset.
Wow.
Yeah.
So list it.
Yes.
List it.
Yeah.
You might be surprised, actually, that the most wealthy estates are not from people who held white-collar jobs.
If your life was to take an unexpected turn tomorrow, would your loved ones, your family, know exactly where to begin? Ladies and gentlemen, our clients and our future clients who've logged on to this call, welcome. My name is Diana Sheffo, a client success manager within the Group Life department, and I am happy to be your host for this session. Every day, we get to see how wealth is created. We see people moving from owning one property to a number of properties, from owning 10 cows to 100 cows. But we often say that wealth is not just what you create, it is what you protect and how you pass it on. At Zamara, we believe that powering prosperity is shifting from accidental legacy to intentional planning. And you do this by planning your estate. Within the next hour, we shall discuss more on estate planning, and I'd like to invite you to ask any questions you might have on the chat section, and we shall address them during the webinar. In line with this month's celebration of Women's Day, we are proud to host a panel of women. And I'll start with my farthest right. She's a force to reckon when it comes to employee benefits. She's a seasoned insurance executive and the general manager, employee benefits at Zamara Risk and Insurance Brokers. She provides strategic leadership in the design and delivery of comprehensive employee benefit solutions. She has built a strong track record of advising organizations on integrated benefits programs. She's also known for translating complex risk into forward-thinking and commercially sound solutions. Liza Nyaga, thank you for being part of this panel. Please tell us, what is one activity you enjoy doing outside work?
Thank you so much, Diana. Excited to be part of this panel. Today, if you counted and told all recording artists, anybody that has recorded a song in studio to stand up, I would stand up together with them.
Wow.
Yeah, so music is a big part of what I do and what I love, and that is what I enjoy doing outside the office.
Wow, okay. Good to know. Our next panelist is a seasoned in-house counsel and a team leader within the legal, governance, risk, and compliance department at Zamara. She has extensive expertise in corporate, commercial, property, and succession law, as well as financial services. She also serves as a company secretary, a trustee, a certified data protection officer, with a strong passion for helping organizations strengthen governance and align with evolving regulations. Ms. Damari Etemesi Yvonne, thank you for being part of the panel.
Yeah.
Please tell us, outside work, what's one activity you enjoy doing?
Thank you, Sheffo, for that good introduction. Outside work, I enjoy watching Formula One. I'm a very, very big fan of the Formula One motorsport.
Okay.
I want to understand how the cars are performing, by what seconds, which car is performing better than the other. Aside from that, I want to know what motivates the drivers, what makes the drivers perform the way they do.
Okay.
I want to understand, what drives the team that then builds that particular car that enables the driver to drive the way they drive. So I'm really intrigued by that sport, and that's what I do outside work.
Wow, a lawyer who loves speed. Our guest of honor joined the bench in May of 2024 at the Milimani Law Courts Family Division. She previously practiced for 20 years at Namisi and Company Advocates, specializing in family, land, and commercial law. She also served as the chair of the LSK Nairobi branch in 2022 to 2024 and was the first female chair of the HIV and AIDS Tribunal in 2019 to 2022. She also lectured at the Kenya School of Law. Lady Justice Helen Namisi. Thank you for joining us and welcome to the Zamara community today.
Thank you very much.
Please tell us, for someone who carries such weighty responsibilities, what do you do during your free time?
So during my free time, I carry a weighty instrument. Like Liza, I really enjoy music. I don't think I've recorded anything, but I play one of the largest instruments you'll ever see on any stage, the double bass.
Wow.
Yes.
Wow. That's interesting. Okay. So now that we have the law represented by Lady Justice and we have the strategy represented by Zamara, Liza, and Damari, we can now begin. But before that, just to remind you to engage with us on the chat section, please ask any questions you might have and we shall address them during the webinar. My first question is to you, Damari. When we talk about estate planning, what are we talking about? What is an estate?
Thank you, Diana, for that question. I would say an estate involves everything that you own. Could be both movable or immovable property. So think about your land, your cars. If it's a company, think about the shares that you own. Think about your livestock, your pets, everything that you own, your investments in different banks, etc. All those things form what we call, in law, your estate. So when, for instance, someone particularly dies, the estate will comprise of all those assets. So it is important for you to know exactly what you have, because what you have then determines how you then plan for instance, your children, your spouse, your relatives, everyone that you care about right now, and you're able to organize exactly what you have and are able to plan for them. So it offers a kind of security and protection. So it is very important for anyone who's listening to understand that you need to plan for what you have to enable you know how best to then protect the people that you love and care for.
Okay. Thank you, Damari. Maybe just a follow-up question. Do our liabilities form part of our estate?
Yes, because what will happen then upon the death of a particular person is that any person who, the person who died owed any some sort of debt would be ideally listed as part of the people who would benefit from that estate of that particular person. And I believe the judge will be speaking to that later on. So yes, your debt will form part of that estate, and the people who you owe certain debts to can be listed as among the beneficiaries to that particular estate.
Okay.
So yes.
Thank you, Damari. Maybe Lady Justice, from your experience in the Kenyan context, what is the most common mistake people make when they are planning for their estate?
Wow, that's a loaded question. I think the most common mistake that we all make is imagining that we'll live forever. So we don't plan because it's a typical African myth that if I start planning for my death, I am inviting it. So we don't. We just live each day as it comes, and you don't want to think about the eventuality of your death,
Okay.
which we know 100% is going to happen.
Yes.
So I think that's the biggest mistake that we make.
Okay.
Yes.
From a legal standpoint, does a spouse automatically get or inherit everything in case a member passes on?
Does a spouse inherit everything?
Yes.
No,
Okay.
it's not automatic.
Mm.
No, because it is possible for the deceased person to have written a will and said, I do not want this person to get this or this. You've given some items to your children, for example, or some relatives. Or, we've even seen cases where you give it to charity. So you give everything you own to charity and leave maybe something for your spouse.
Okay.
And then it also depends, sometimes the deceased person may not actually have anything. So you're sitting there as a spouse thinking, when this person dies, at least I am assured of this, only to realize that maybe all those things they held were never in their names. So it's not what we call free property. Yes.
Okay. Okay, thank you for that. Maybe a question to you, Liza. Is estate planning just for the wealthy? Because there's this assumption that for you to plan your estate, you need to have some sort of money. And maybe we've seen from the movies, when you talk about a trust, you associate it with someone who is wealthy, someone who has money. So is estate planning just for the wealthy?
All right, thank you. The direct answer is no. And just looking at the data and what Lady Justice has said is that succession or estate planning is not automatic, that it goes to a specific person. And really, it's the reason that even when you look at the data in just Kenya, and I know these people from various demographics that are, different countries that are watching us this morning. But just looking at the data from Unclaimed Financial Assets Authority, sitting with between 57 to 115 billion worth of assets.
Wow.
And various other reports actually suggest that when you look at what has not been reported to the authority, what is sitting in inactive bank accounts, unclaimed dividends, dormant insurance policies, could be way over 4 trillion Kenya shillings. Can you imagine? You could be a billionaire somewhere, but your grandfather did not report, did not tell anybody that they own, they own property. You've seen caretakers that become rich overnight because the landlord stopped coming, and they started collecting the rent, isn't it? So I think, and even among the wealthy, there's the ultra high net worth individuals, and there's the rich, and then there's the middle class, and then there's the poor, But even the middle class and the rich only believe planning is for the ultra high net worth, which is, I think, 125 families in Kenya alone, But really, I think looking at the data, it's for everybody. It doesn't matter what you own. As Damari said, you own a car. You own a kashamba you bought in Kamulu, know. You own your fridge, your microwave. Those are the things that people fight over, isn't it? I mean, you've seen it in the news. So it's not stuck to only the wealthy or the people that own a certain limit of money for them to plan. Estate planning is for everybody. Yeah.
Thank you. Thank you, Liza. Maybe, Damari, when we hear the name estate planning, what comes to mind is a will. So maybe from your perspective, what makes a will valid?
Okay. Maybe, Dan, I can start by saying that the law provides for 2 types of wills. We have the oral will, which is just a will that is given by word of mouth. Then we have the written will. Now, for the will to be valid, the law provides on what needs to be done to ensure that particular will is valid. So for an oral will, the law provides that, number one, when you're making those expressions, let me call them expressions. When you're making those expressions have to be before 2 or more witnesses. So think about your family situation, maybe where your father calls you and your father is always saying, when I pass today, I want this house to go to my son. I want this particular car maybe to go to my daughter. The law provides that though when your dad is making those remarks, it has to be in the presence of 2 witnesses. Important if it's in the presence of 2 independent witnesses, because you don't want questions where people start asking, okay, so why did dad, for instance, say in front of you and you alone, left the other child, etc. So to avoid those things, the law provides that it should be before two independent witnesses.
Okay.
And then when he's making those particular expressions, the law also provides that they need to be made within 3 months prior to his death. So, for instance, if your father surpasses those 3 months, then judge will tell us it's a question now of interpretation.
Okay.
Like, because what the law provides is that something, if it's beyond the 3 months, then it is assumed that he survived that particular thing, that they were maybe that they survived the death and they could have changed their mind.
Okay.
So for the word of mouth, the expressions have to be made within 3 months. It's for the judge, for the court to interpret to us what the 3 months and when the 3 months started running.
Okay.
So, and then another thing you'll be looking at is that when your father was making those expressions, they were, for instance, not influenced in one way or another. Their state of mind was okay. They were not drunk. They were just not shouting, etc. They were not influenced maybe by one child to make those expressions and leave out the other children. So the mind, the state of the mind was okay.
Okay.
So, and then when it comes to a written will, same thing. The will has to be, of course, written down. It has to be signed. The person who's writing must to be of capacity, and by capacity we mean you have to be both mental, physical capacity has to be okay. You have to be someone who's over the age of 18. Of course, minors cannot write the will. The will has to be signed, and then the will has to be witnessed by 2 independent witnesses. So those are some of the things that make the will to be valid.
Okay.
Again, those will be the same things that will make the will to be invalidated. So if any of those things you wrote the will, but you did not sign it, or you wrote the will, but it was not witnessed, or you wrote the will and you are going through some form of coercion or any form of duress, those are some of the things that, yes, validate the will, but again, those are some of the things that could make the will invalid.
Okay.
Yeah.
Maybe just a follow-up question. Why do families end up in court despite having a will, whether written or oral?
yeah. I think one of the reasons that we've seen, and maybe the judge can expound because she deals with them every single day, is that for instance, one of the things, aside from the things that I've said, is that maybe you fail to provide for maybe one child. It's called adequate provision,
Okay.
where you provide for one more than the other. It could be challenged on those grounds, especially if it's children, whereby one child could be saying, so why did dad provide more to you, for instance, Diana, than me? So you've given 60 and you've given 40. It could be one of the reasons, because the law provides that both children should be treated equally, or all the children should be treated equally. So one child might feel like they were not adequately provided for, and so they might approach the court for the court to listen and try and understand why maybe your dad provided 60 and the other one 40. The court will listen, but the court will not necessarily alter the provisions of the person who was making the will. And maybe the judge, you can expound on that.
Tell us.
Please tell us.
So your question was, why do families end up in court?
Yeah.
Despite having a will.
Whether or not you have a will, let's just be clear, succession can only be done in court, nowhere else. So there's no other way to do succession, despite what many people believe, that we can just agree and do it at home, maybe in front of a chief. That's fine, no problem. But at the end of the day, you have to come to court to get, you need to get your grant, you need to get the confirmed grant for you to be able to transfer the property to the beneficiaries. There's no other way. Even when you go to the lands office, you'll be asked, where is the letter? Where are the letters of administration? Where is the confirmed grant? So whether you like it or not, you must go to court for succession.
So even if the will was very clear,
You have to go to court. Yes. Now the question is, what kind of experience are you going to have there?
Yeah.
If you have a will and everybody has agreed, this is how we are going, Mzee said this is what we're going to do, or the lady, and everybody's in agreement, then it's very simple.
Easy.
Okay.
And it will take you a fair short amount of time. However, if we are still push and pull here and there are some who we do not want to acknowledged as beneficiaries, or we have assets that somebody is hiding somewhere, especially if you have intestate, which is where you die without a will, then this process can take years.
Okay.
Yes.
Actually, that was my next question. What happens when someone dies without a will? From experience, what are some of the challenges families face in such a situation?
Well, when someone dies without a will, that's what we call intestate.
Yes.
And generally, what happens is we need to identify who are the beneficiaries, who are the dependents of the estate. And then we have to identify what are the assets and liabilities of the estate. So put them all into one basket, and then we know we have X number of beneficiaries. Now let's start distributing. The easier thing, as I said, would be if families agree. Then they come to us and say, this is the person we have selected as our administrator, who is going to manage everything. Just manage, not distribute, manage.
Yeah.
And then sit down and agree, this is how we have agreed. We have X number of assets. We have offset the liabilities. We've paid them off. So these are the net assets we have. And we have agreed this asset will go to person A, this one will go to person B, like that.
Okay.
And then all the court is doing is confirming and ensuring that all of you have agreed. Yes.
Okay.
If there's a child, that child is cared for. If there's a person living with disability, that person is cared for. If there's an elderly spouse or mom who was a dependent, then, that person is also cared for.
Okay.
That's it. But if they do not agree, that's when you see people will live in court for years. And that's what we try to encourage you not to do. Try, go and resolve, because at the end of the day, you're a family and you're going to have to come back to live as a family.
Yes.
One question I always ask in court is, where are you going to spend your Christmas? So think of that. Where are you going to spend your Christmas? It's with your family.
Yes.
So if you cannot agree, what happens on that day? Christmas Day.
No one shows up.
Yes.
Okay. Thank you, Lady Justice. Maybe Liza, my question to you is whether group life benefits form part of one's will.
We had a serious debate on that one as early as this morning. And I think even before we go to the two schools of thoughts around whether they form part of your estate or not, it's important to tell our viewers, those who might not have interacted with group life assurance, what it is. So we started with WIBA, which covers the employee in case of any work-related injuries, occupational hazards, and things like that, pays out a certain benefit to the beneficiaries in the event the injury or the death is as a result of work-related injuries, right?
Yes.
So, and that is by law, it's statutory.
Yeah.
And then people asked, what about if I have an accident when I'm going to work, or I have an accident coming out of work, then who covers me? We brought in group personal accident.
Yeah.
That sort of gives you a 24-hour cover.
Yes.
Now, what if your employee dies as a result of a natural cause or an illness? You've seen the deaths around cancer and all these cardiovascular diseases, non-communicable diseases. And that is why group life exists.
Yes.
It covers you in the event of death, critical illness as a result of all causes of death, whether accidental or natural or illness.
Yes.
And so this policy is taken by the employer on behalf of the employee. So the first school of thought is that because the policyholder is the employee, then they're at liberty to take the benefit and offset any debts, say, the employee had. If they had given a loan to the employee, they can take the group life benefit in the event the employee has died, offset the loans, and then give the balance to the beneficiaries.
This is the employer.
Yes.
Yes.
Yes. Now, that caused a lot of uproar, including myself. I was in that team, saying, why would you take my benefit? It is in my contract. You gave me a contract at the beginning when I was joining the organization, and you said, you're going to give me a medical benefit, you're going to give me a group life cover. So why should you do that? Now, the other school of thought is from the employer side. I'm the policy holder. I have paid the premiums on your behalf. I have given you a loan. Why should I not deduct?
Yes.
And the employee says, no, but we have an MOU with the bank it's not that you give me the loan from your office coffers. I have an MOU with the bank. I paid a credit life insurance to
Yes.
protect that loan in the event I
Of
die.
anything,
Yeah.
Yeah. And maybe that is one of the things that employers can do instead of taking away part of the benefit is to protect the loan.
Yes.
So those really are the two schools of thought. I will leave it to the audience that are watching to tell us on the comment section
Yeah.
what you think should happen. Because really, if you look at, does it form part of your will? No, because ideally it should be paid to your nominated beneficiaries. So when you're taking over the group life cover, there's a form that you fill and you say, these are the people that will get the benefit in the event of my death. Same to your pension benefits.
Yes.
Yeah,
Yes.
it should be paid to your nominated beneficiaries.
Beneficiaries.
But these are things that we need to consider. If you take a loan, if you have ABCD, as you had, liabilities form part of your estate.
Yes.
Yeah. So make sure that you protect those loans for the employers that are watching, so that then you do not need to take the benefit and pay
Use
it
to
behind
reset. Okay.
the curtain.
Okay.
Yeah.
Okay, thank you, Liza, for that. We've talked about the will, but maybe just to move to another way of planning your estate, which is a trust. And my question is to you, Lady Justice. At what point should someone consider setting up a trust? And in what situations does a trust become more effective or a more effective tool than just relying on a will?
That's an interesting question. I've seen a lot of debate about the two on social media recently. I think making the decision between a will and a trust is a very personal thing, and you have to have considered some of the benefits, because I believe there are benefits in trusts over wills. I remember several years ago actually speaking to somebody who is in tax,
Okay.
and they said, they do attract some tax benefits.
incentives, yeah.
Yes,
Okay.
so that could be something that then encourages somebody to take a trust, to opt for trust as opposed to a will.
Okay.
So the difference, I believe, would be that when it is in a trust, it's not entirely yours. It's not your property anymore. If it's in a will, it's mine. I can do with it as I please. And then, in future, I can write what we call a codicil. Maybe I have an asset. I have the plot that Eliza was talking about in Joska. And then tomorrow I sell it and I buy another one somewhere else, Ruai. So whereas I wrote a will that had Joska, I can write a codicil later on that has this Ruai one. But if I wanted to dispose of a property that is in a trust, it wouldn't be as easy.
Okay.
Because it's no longer mine, particularly if the trust is incorporated. You see, it belongs to another entity entirely.
Third party.
Yes, it's not mine that I can do with it as I wish. That's one of the differences between the two. So you would consider whether you think you would want to deal with it freely as you would in a will, because with a will, you go about your life. It's just that you're acquiring and maybe changing, selling a few assets, no problem.
Okay.
But in a trust now, it's gone beyond you. So it's in another entity.
Okay.
So you can't deal with it as freely as you wanted. Of course, there's a lot more protection in a trust in that sense, because now you'd have to, sit down and really consider. It's not something you can just wake up and call a broker and say, I want to sell this particular property.
Yes.
You'd need to really think about it. And then, the trust has the tax incentives, as Damari has said. So, speak to a tax lawyer or a tax expert and see what are some of the benefits you can derive from that. And to some extent, then a trust would be, it's already determined. So we already know who the beneficiaries are, and we know that it is in equal share. But with the will, I can give you more than I want to give Damari.
So for a trust, it has to be
It's
equal
an equal share.
Okay.
We're all beneficiaries, so we are benefiting from it equally. But in a will, I can decide. I think when I was sad that day, you gave me a hug, so I'm going to give you the plot in Karen. I think Damari, well, she bought me tea the other day, so I think I'll give her the one in Joska. And then I say, and the rest of it, I want it to go to charity.
Yeah.
Okay.
So, yeah, and I don't have to, well, I could justify in terms of children why I'm giving one child more than the other, but not necessarily.
Okay.
If I leave out one entirely, then that's different.
Yes.
But with a trust, it's more or less set. We know it's equal. Yes.
Okay. You've just said that a trust is not entirely yours. So there's a third party managing the assets on your behalf. So how safe are those assets in a trust?
It's not a third party. It's I become the trustee, but I'm holding them on behalf of the beneficiaries. So for instance, if I have 5 children, those are the beneficiaries of a trust. So I am holding it as trustee for them.
Okay.
So I will deal with them as a trustee, but they're not my individual assets. I am a
Okay.
trustee.
Okay.
Yes, so there's that difference in the duties and obligations of a trustee, as opposed to when it is mine, the title is in my name. I can wake up today and go to a Shylock and I will borrow against it, or I can decide to, I don't know, transfer it to somebody who I like. It's, it's entirely up to me what I want to do with it. But if I'm holding it as a trustee, then I have a special duty to the beneficiaries, and it's different. The duty is different.
Okay.
Yes.
So are you, okay, maybe from your point of view, are the assets safe with a trustee?
Yes, they are.
Okay.
Because first of all, you have a whole law. You have the Trustees Perpetual Succession Act.
Okay.
So you have a whole law that is defining this relationship and is saying what the trustees can do.
Okay.
And then remember, what as I said, once it's incorporated, it's a separate legal entity.
Okay.
So it is running in perpetual succession on its own. You can change beneficiaries now and then. You can change the trustees,
Okay.
but it's a separate legal entity. So yes, the assets are safe. But again, you're dealing with human dynamics always. So even like you may encounter some challenges with a will, and similarly, you can encounter challenges with a trust. The thing to say is you are facing less risk if you choose a trust or a will, as opposed to sitting and waiting for nature to take its course and things to sort
happen.
themselves out,
You will figure it out.
and say, when I'm gone, you sort yourselves.
Yeah.
Okay.
Yes.
Okay. Thank you, Lady Justice. Maybe Liza, we've heard about nomination of beneficiary forms. What are nomination of beneficiary forms, and what is the difference between a nomination of beneficiary form under pension and under group life?
Okay. I think I mentioned this when I was capturing the previous question, that when you're employed and the employer has procured a group life solution or a pension benefit for you, there's those forms that you fill. And ideally, those forms nominate who your beneficiaries are. They say, in the event of my death or in the event of anything, I want you to pay 50% to my spouse, or, for the women, I think there's an article the other day that we leave all our properties to our children, 100% to my children, nothing to the spouse, whatever it is your situation is, but you have nominated your beneficiaries.
Okay.
Now, under pension, it is guarded by the trustees. So the trustees can take that form and say, okay, these are the people that she nominated or he nominated, but there's an extra beneficiary somewhere, maybe a child out of wedlock or whatever it is. And they can then make that decision to allocate your benefit accordingly.
Yeah.
Now, what changes and what a lot of people do not do is update that form as your life situation continues. For example, when I joined employment, I was a single girl. Now I have 2 children and a spouse. So at what point did I change? There's some people even get remarried.
Yes.
And maybe your original form still has your original spouse.
Yes.
So it is important that as your life changes, as you change your spouse, as you get more children,
Yes.
or, there's some, if you're single, you can nominate your father and your mother, but what if they pass on? Are they still the beneficiaries in your nomination of beneficiaries form?
Yes.
So it's important that you change those forms as your life, continues.
Okay.
Yeah.
So viewers, it's very important for you to change or update your nomination of beneficiary forms as soon as your circumstances change. Okay. So my next question is to you, Damari. Could you please explain what a power of attorney is, and why is it an important tool for managing your affairs during your lifetime?
Okay. So a power of attorney is it's a legal document that enables you to give authority to someone else to act on your behalf or to represent you. So for one reason or another, you might, for instance, be incapacitated in one reason or another, and you maybe need help with something. So you might appoint someone to represent you, and that person is what you give the power of attorney. From a company perspective, think of how the companies, for instance, appoints a CEO or the directors to act on their behalf and represent them in certain matters pertaining to the company. So that legal document that gives them the authority to act and represent the company is what we call a power of attorney.
Okay.
So practically, does it help you manage your affairs? Yes, in certain circumstances. So you might have what we call a general power of attorney or a special power of attorney. A general power of attorney would allow the person that you're given authority to act on your behalf to do all sorts of things on your behalf, all manner of acts to do that on your behalf. But if it's specialized or limited, it's for a specific purpose. So if you wanted that person to maybe operate your bank account, they would only be limited to operating your bank account. And then the other thing that would be important for people to know is that, you can revoke or you can cancel a power of attorney. If it's a general, if it's special, you have the power or authority as the person who gave the authority to that other person. We call them in law, we call you the person giving the authority or the donor, and the person receiving the authority from yourself is the donee. So you can cancel that authority anytime and replace with another person that you may want.
Okay.
Yeah.
So I think you've mentioned donee,
Yeah.
right? The agent, the person being appointed.
Yes.
Okay. So are there any rules around appointing the agent? Let's say maybe from the same family. Are there any rules
Not
around the same?
necessarily, Diana. Nothing limits you from appointing any person to represent you. The law doesn't necessarily limit the person that you can appoint to act on your behalf. So you can choose any person to act on your behalf. However, the law is very specific when it comes to power of attorneys with respect to, for instance, land transactions. So if you want to appoint someone to give them authority on matters land transaction, that power of attorney has to be registered for you to have legal effect in law.
Okay.
So you have to make sure that for land transactions, that power of attorney has to be registered.
Okay.
Yeah.
Thank you, Damari. Lady Justice, we've had cases where when a member passes on, the family is not able to access maybe bank accounts and such things. So from your experience, what are some of the, why do families face delays in accessing funds when someone passes on?
So I think that question should have been for a banker, but so generally when someone passes on and the bank is notified, they freeze the account.
Yes.
Right?
Yes.
Because the owner of the account is no longer there.
Yes.
And nobody else has mandate to sign to do any transaction relating to that account. So why families face delays? Sometimes it could be because they don't even know the accounts exist.
Yeah.
Okay.
So they don't know. Or they know of one, and then when they get access to that one, when they go to the bank, they're told, oh, by the way, and then there's this other one, there's this fixed deposit, there's this other, there's this. So they have to come back and get authority to access those ones as well. Another reason why there might be a delay is, as I said, the accounts are frozen. So generally the law requires that if you want to access the accounts, you must come for a special grant from the court, so that the court gives you that authority to go and access, and to a certain limit. It's not that now you're going to have free reign over the accounts. And you have to come and justify why why is it that you need these accounts. So you have instances, for example, there are children going to school, rent has to be paid. Maybe this was the sole breadwinner. So these accounts are really important for the survival of a family. So in that instance, and you have presented sufficient evidence to show that this is needed, then you will get the special grant. We will allow you go and access, and take out the money and pay. Sometimes it's specific. It says this money to be paid to this institution. Maybe it's even bills. You could have a situation where the deceased left a hospital bill.
Yeah.
So you have to access the account
Yes.
so that you can clear the bill, because the hospital might not release the body until you have
Yes.
cleared the bills.
Yes.
So you need that special grant. Come get it. Present to us the evidence. Why do you need that grant? If the evidence is sufficient and the family is in agreement, because again, remember this is the estate. So as you're chipping away at it to pay off bills, to pay school fees, there's less and less to be distributed in the end.
Yes.
And whoever gets this grant, the administrator who will be given this special authority to be able to access the accounts, has to present accounts to the court. This is how much was in the bank. This is how much I accessed. This is where it went.
Okay.
So that it's not, as I said, it's not free reign.
Yeah.
Yes.
Okay. So this special grant, is it given for a specific duration?
Yes.
Okay.
It could be given for a specific duration. It could be limited to, say, 6 months. We've given you a grant for 6 months to go and access accounts, because we're also encouraging you to speed up the succession, the main succession, so that we're not here forever and ever just dealing with special grants. We want you to move on with
Yes.
the main petition itself, or with the main succession.
Yeah.
So it could be limited to 6 months. It could be limited to a year. And then after a year, if you need to come back and say, we haven't been able to do this and this, we need an extension, justify it and you can get the extension. Sometimes we can give you for school fees for one term. Go and access, yes, because that's what you asked for. You asked for school fees for one term, so we give you for one term. So you come back and say, okay, now we're in a new term, we need school fees again. Or even a situation could arise, one child now suddenly becomes sick, or the spouse, and you need special medical attention. You need to access the account.
Yes.
So yes, we will grant you that document to be able to go and access the accounts for that need.
Okay.
Yes, but
So
it
the
is
grants
limited.
need to be very specific.
Yes, and it's limited. There is also a different one where you're given the authority to collect. So maybe the deceased had properties, there was rental income coming from somewhere. Maybe there was somebody who owed money. There's a loan, he lent money or she lent money. There's a loan that you're expecting to collect something. Maybe
Yes.
there's some dividend somewhere.
Yes.
So you can get a grant, and that one is specifically to collect and manage, but not to use.
Shucks.
Not to use.
Not to use.
To collect and keep
Collect,
it safe
yes,
somewhere.
and manage, but
Okay.
not to use. You can use maybe if you're offsetting liabilities like tax
Yes.
or utilities, you have to pay utilities. You have to, overheads, expense, those things.
Yeah.
Yes, but not to pay yourself or to start dividing amongst yourselves. No.
Okay. Wow. Thank you, Lady Justice, for that. Damari, maybe the next question is for you.
Yes.
How are investments and pensions treated in an estate?
Okay.
Probably when you're answering, maybe you can also touch on gratuities.
Okay. Just like what Liza said, pension benefits are treated differently because they do not form part of your estate
Okay.
on succession, because they're managed by a different type of law, which is the Retirement Benefits Act and the various regulations therein. So if someone passes on and they had pension benefits, like what Liza had mentioned, the deceased person ought to have filled the nomination of beneficiary forms,
Yes.
which would then stipulate how they intended their pension benefits to have been administered.
Yeah.
Just like what Liza had said, the trustees who then govern that aspect of pension can change the circumstances here and there. For instance, to add a beneficiary who, for instance, might be a child who had been left out and they need to be catered for, they need to be provided for. But generally, they would ideally follow what you had provided for in your nomination of beneficiary funds. So it's in very limited circumstances that the trustees will then go to alter that provision that you had already made to your beneficiaries. When it comes to investments would be treated in the same way, just like you would have provided for them in the will, saying, for instance, my shares in this company X to go to A, B, and C. The law, from a succession point of view, is the same. The investments will be treated in the same manner.
Thank you for that. Liza, there's this perception that writing a will is very expensive, it's complicated. What is your view? And how can one just start?
I have a lawyer and a judge in the house who can tell us if it is expensive. So from my little research, I found there's actually very many ways of writing a will. You can do it yourself. Just take a piece of paper, write your assets, nominate your beneficiaries, etc. But I think the advice is to use a lawyer if you can. It can vary depending, of course, on the experience of the lawyer, depending on how vast your estate is or your assets, how complicated it is. Are they owned jointly or individually? So the cost can vary.
Okay.
But then when you look at the cost vis-a-vis the pain that your beneficiaries would go at or go through if you have not planned it, then it makes sense. Yeah. And I'm sure you can all Google and see what those costs are. 10,000, 50,000, 100,000, over 100,000 millions, depending on all those things. I think Damari went through the requirements of a will. Needs to be valid, needs to be signed, you need to have independent witnesses,
Yes.
who are not part of your beneficiaries.
Yeah.
The key thing to start is by listing your assets. I think that's number one. Some of us do not even know our net worth.
Yes.
We think net worth is for the 125 families we spoke about.
Yes.
Yeah. You have a land that you bought 10 years ago and you've not even had it valued.
Yeah.
You don't know the value of that land today.
Okay.
How many of us today know how much is sitting at NSSF, your pension, which you contribute to every single month? Do you know how much is sitting there? Because that's part of your property.
Yes.
Yeah.
True.
So the key is to start.
Okay.
Yeah. At Zamara, I think we have an app that you can log in. If you're one of our pension clients, you can log in. You can nominate your beneficiaries. You
Yes.
can see your contributions up to today, where you're at, how much has been invested in there, what interest you got last year. So it's important. Just start.
Yes.
List your assets. Okay, and then ask yourself, who are your beneficiaries? Identify them.
Yeah.
Who do you want to give what? And then your instructions also need to be clear. You cannot say distribute equally to my family. Who is your family? Is it just your spouse? Is it your spouse and your children? Is it your spouse, your sisters, your brothers,
Exactly. Yeah.
very clear instructions.
Okay.
Then, of course, appoint an executor, someone who will, of course, not fleece the rest of the family. It needs to be someone who is going to treat it with, the decorum and the intentions that you had when you started,
Yes,
isn't it?
yes.
Then, of course, execute it. Have your 2 independent witnesses that are not your beneficiaries, of course, conflict of interest, and then store it safely. Yeah. And then obviously update it regularly. Then I think we're living in a world where there's a lot of information. If you need to know about trusts, ask. There's all these webinars. Institutions are willing to give this information for free. So do your research. Identify at what point do I need to put all these things in a trust? How do I go about it? The information is out there. Yeah. And you can always reach out to us if you need any information on these things.
I think just
Yeah.
to add on what
Yeah.
Liz is saying, I think the emphasis is that anyone can write a will.
Yeah.
At any given time, anyone can do it. And over and above that, one thing that she said, please let people know. And I think the judge had said, at times, people don't even know that you have a will somewhere. You've not confided in any friend. You've not shared it with anyone. So you might, if you don't tell people, you might actually be presumed to have died intestate because no one knows.
Yeah.
Thank you. Lady Justice, maybe one question to you. There's this perception that will writing, succession planning, estate planning is for white collar jobs. You know, is that true?
Absolutely not.
Not.
Just as Liza has said, to start, you simply have to list your assets. And the assets are not just the plots. It can be anything. Do you know your M-Pesa account is an asset? You know, your M-Shwari. Similarly, your Fuliza is an asset. You have your list of assets, you have your list of liabilities.
Yes.
Anything is an asset. I mean, we are working right now. We are dressed, are we not?
Yes.
These are assets, are we
Yeah.
not?
Yes.
These are personal effects. Yes, so we all have personal effects. I don't think there's anybody on this planet who does not have personal effects. As I've said, you have your M-Pesa, you have cash. If you had cash, if you have money in your wallet, that's an asset.
Yes.
You have a bank account somewhere. Regardless of whether it has 1,000 shillings or 1 million shillings, it's an asset. It is something. Maybe you own a goat or a chicken. It can even be a chicken. Or
Paintings.
Yes, paintings. You have a beehive somewhere. Right, that's an asset. So it's not white collar jobs only. Anything and everything is an asset, as long as think of it this way: if you did not come to this planet with it, it's an asset.
Wow.
Yeah.
So list it.
Yes.
List it.
Yeah.
Because we came with nothing.
Yeah.
So everything we have right now, assets or liabilities. Yes. List them.
Yeah.
Okay.
And then say, this is how I want my assets to be distributed.
Okay.
It's that simple. So
Yeah.
I wouldn't say it's white collar jobs only.
Only.
You might be surprised actually that the most wealthy estates are not from people who held white collar jobs.
From business owners.
Yes. Business. Just think about all these. Let me use the example of landladies in Eastlands, because it's the landladies. It's landladies in Eastlands. In Eastlands, renting her to pick up.
Yeah.
She will never realize just how
How
wealthy
much?
she
Yeah.
is.
Yeah.
Yeah.
Okay. So now, for business owners, from your experience, what should they keep in mind when planning their estate?
For business owners, I think the onus is on them to go beyond just their own estates, because you have a business now. So depending on how your business is registered, if it's not a company and it's registered as a business registration, it's just that it's a business. Then it is yours. So it actually forms part of your estate.
Yes.
So when you're considering succession in your business and your life, then you have to consider both.
Yeah.
Because for a company, it's more or less taken care of. You have the Companies Act is going to deal with that. It's a separate legal entity. What we will be talking about is your share in the company.
Yeah.
But when it's a business, we're talking about now even the assets of a business. So in the event that the Lord calls you, then what? What happens to your business?
Yeah.
So I think the onus is more. You have to think about the succession of your business as well as your own estate.
Yeah.
So plan the two.
Okay.
Yes.
Okay. Thank you for that. At this point, we shall take questions on the chat section.
Okay.
Maybe I'll start with the Lady Justice. There's this question: how much rights do a man's relatives, brothers, parents have on his property over his wife?
Wow.
I expected So the fight is usually, and interestingly, at this point is when the relatives don't recognize the spouse as the
I
wife
know.
and start saying, in fact, we've never seen this one before. We don't know anything about her, and that's common. That's common. But legally speaking, the spouse is number one. In the hierarchy, spouse is number one.
Whether customary or
Spouse is number one in the hierarchy. Remember, even at that point when two became one, it didn't mean that there are others who are joining in this union. Two became one, not like 3 or 5.
Yeah.
It was 2.
yes.
So the spouse is number one. But then now it's the issue of there'll be some, now, in customary, or where they've simply lived together, unfortunately, she will have to prove that she's a wife. And this is where the in-laws will not turn against her and say, we've never seen you, we don't know who you are, unfortunately. And then another common occurrence, which is also very sad, is that at the point when the man passes on, the relatives will come and sweep that house clean.
Yeah.
And it's very, very sad. Very unfortunate, and you would have thought that in 2026 we'd be seeing less of it, but it's still there. So I think it's, such webinars are important just to also educate women on their rights. To know that when my husband passes away, yes, I am in grief, I am in mourning, yes, but I also still have to look out for myself and my children and ensure that we are protected. So to answer your question, plain and simply, the woman comes first, spouse comes first, and then children, then the relatives, if at all, at the back. Wow.
And maybe to just add, Diana, what the judge has not told them is that those relatives who go and sweep everything, that's illegal.
Yes,
It's illegal.
It's illegal.
You're not supposed to do
You're
that.
not supposed to do that.
Yeah.
But they will do it.
Yeah.
Yes.
Okay. The next question, maybe Damari, you can take this one. What about property that you have not finalized the transfer process? For instance, you've bought a house, payments have been made, but the transfer has not been initiated. It's still at agreement stage. So how
Will
will
it-
that be treated?
Okay. As long as now your family can demonstrate that you had actually paid for it, and it's just, for instance, the transfer that is pending, they can add it, or it can form part of your estate. Nothing stops it from forming part of the deceased estate, because technically you had done the preliminaries, you had signed the sale agreement, money has been paid, so it's just the formalization from the land's perspective. So it will form part of your estate, and ideally what would then happen is that it would then be transferred to either, it would go, depending on how the beneficiaries agree, it could go directly to your children, but in the first instance it will be held by the administrator of the estate.
Okay.
The person who will be appointed as the administrator.
The administrator of the estate.
Yes.
Okay, maybe the next question is to you, Lady Justice. Using Justice Majanja as a case study, kindly highlight why his will is contested, yet he categorically stated the beneficiaries, and it also factored some customary elements in terms of inheritance.
So the good thing about that question is that there's this principle in law that says if a matter is in court, I cannot discuss it.
So we follow it on the news and see that.
Okay. Maybe the other question is to you, Liza. How long does the process of pension take, the process of beneficiaries receiving the pensions once a member has passed on?
All right. I want to believe this is for a person whose beneficiaries are not contested. The trustees have received all the communication. I don't believe it should take more than 30 days.
Yes.
Yeah, it shouldn't take more than 30 days for the beneficiaries to receive the funds. Again, back to what we've been talking about, have you updated your nomination of beneficiaries form? Are there people that you did not include there, for example, that might contest that decision? And number 3, are your trustees in order? Have they been set up? Do they understand their roles, and are they acting accordingly? Those are the only things that might delay the process of getting the benefit.
Okay.
Yeah.
Allow me to ask a question to Liza. I'm just curious because you're saying we need to update this form often.
Yeah.
Would it be good practice, when we are setting our goals in December, 31st December, I'm saying how I am going to start exercising more,
Yeah.
I'm going to eat less,
Yes.
I'm going to, all those nice things we say and never do.
Yeah.
Maybe that would be also a good time to look at all those forms
Exactly.
and just see what situation has changed.
Yeah.
Yes, yes,
And
yes.
update so that it's annual.
Absolutely. You can actually update as and when. So if you have a baby in July, update in July. while. Like
Yeah.
nothing stops you from updating immediately. The situation happens. Yeah, but it can be one of the goals that you set for yourself. Make sure your affairs are in order. Yeah.
So maybe just to add on to what Liza said, so if you're the beneficiaries and you know the particular institution, maybe where your spouse was employed, you can approach them, and then of course you as the beneficiaries would be guided on how or what forms then you would need to fill to enable you then access.
Yeah.
So it's a small process, but start to finish
Yeah.
will take 30 days.
Yeah.
Okay. Yeah. Okay. My next question from the chat section is to you, Lady Justice. In a family situation where land division has been done, where the sons and mothers got their share of the land, then the mother stated that upon her death, the land and the house, her share, is distributed to the grandsons. But some of the biological sons disagree with this decision. What happens after her death to avoid conflict or bloodshed in the family? What should ideally happen?
She said, so we're assuming it's an oral will.
Yes.
We will respect that. Yes. As long as there's a will. You know, if you look at the hierarchy of the dependents, the sons would rank higher than the grandsons.
Yeah.
But if she said that she would like this property to go to her grandsons, and it meets the tenets that Damari spoke about with regard to an oral will, then we will respect that. Yes.
It's that straightforward.
Yes. However, as I said, in terms of hierarchy, the sons would rank higher than the grandsons. Yes,
Okay.
because the grandsons ideally should be inheriting
From their own,
fathers.
yeah.
Okay.
Yes.
Okay. Well. Okay, Damari, the next question is to you.
Okay.
Does having a joint account protect the spouse in any way in the event of death of one spouse?
I think yes. And maybe the bankers online can also can also chip in, but I think yes, because in the joint account, it most likely provides for how survivorship would happen. That if one spouse passes on, maybe automatically the other one has rights and can ideally access the bank accounts. But you know, we can research more about it.
Okay.
Unless Liza or the judge want to add.
It sounds straightforward as the
Yeah.
ordinary Monanchi sitting on this panel. Like if you have a joint account, as opposed to, because the process you talked about, Judge, for me sounded extremely complex. If my spouse passes on, where do I have to keep going back to the court to ask for a grant to access the money? For me, that sounded, knowing our court process, it just sounded extremely complex, administrative. It sounded like a nightmare to me. So for me, the option of having a joint account, it actually sounds like an easier way of doing things if you're managing a household. Yeah. I don't know.
Well,
I understand it's protecting the estate of the deceased, yeah? So that I don't go and buy myself a Lamborghini, but
but I don't think it's that complex actually, because you can literally get that grant in a week.
yeah, okay.
It's
to
just
know.
that I think people fear going to court.
Yeah.
They fear.
Yeah.
Fear. It's like, sending shivers down your spine.
Yeah.
But it's not that bad. I mean, we're humans there.
So the next question is to you, Lady Justice, again. So this one is on a life insurance policy where someone bought it before they got married and listed the dad or the. Then on the will, they stated the wife as the sole beneficiary. So which document supersedes the other?
Can you see how that question is for Liza?
It's perfect.
Oh my gosh, Judge. I don't know which document supersedes the other, because I think that is more common than we care to admit. So, and the question is, which document is superior. If we come to court and maybe somebody had a copy of that life insurance policy and says, look, I was listed as the beneficiary here, but the will says something different. As the judge, which document do you use?
Remember what Damari said, that policy is not part of a will. Yeah.
So that is separate.
Separate,
So
yeah.
go with what they signed.
Okay.
Yes.
So it doesn't.
Signed the will.
No.
What
With
was the life insurance policy?
Yes.
Is not part of your estate.
Okay.
Yeah. So it will be paid to the nominated beneficiaries. Yes.
Okay.
Yeah.
Wow. Okay.
But you can't have a will and a trust. Can you have a will and a trust?
Different properties, yes.
You can.
Yes.
Okay.
Maybe another question. Can a child born out of wedlock to an already married man be eligible to an estate?
100% yes.
Explain.
Child shares DNA with that
Man,
Yeah.
yeah.
full stop.
Yeah.
You
Yes.
have to prove.
It doesn't. Well, yeah, but some things are. It's like if you bring the photo of the man and you see the, I surely. No, I'm not saying that that's the only evidence. But I'm saying that a child born out of wedlock has the same rights
Rights.
as the one who was born in the
marriage, yes.
It makes no difference how they were born.
And is that regardless of whether the deceased was supporting them or not?
Yes.
Yes.
It is.
Yeah.
Okay.
Okay. Okay, Damari, in case someone writes their will on a piece of paper and gives it to the area chief, can it be implemented?
Well, as long as the will is valid, you wrote it properly, it was signed, it was before two independent witnesses, and in this case, is the chief the executor? Is the chief the person you have appointed as the executor? If the answer to that question is yes, then yes.
Okay.
Yeah.
So it will only work if the chief is the executor of the...
Or the chief could be your confidant, the person that you're giving the copy to, that in the event of anything, please come to my family and tell my family that I had actually written a will.
Okay.
Yeah. So yes.
Okay. Thank you, Damari. Liza, maybe you can tell us treatment of investments, for example, shares, stocks, bonds, do they form part of one's estate?
I want to believe they do. They form part of your estate. And it's probably one of the things we don't consider or we don't remember. So they do. They do form part of your estate. Yeah.
Actually, that's why you find a lot of them in the
Unclaimed.
Yes, unclaimed assets.
People who bought Safaricom shares when they were
Yes.
forgot about them.
Completely. Yeah.
Okay.
Yeah.
So my final question on the chat section is to you, Lady Justice. In case where someone had multiple wives with many children and their wealth is tied to a company, the company owns the land, the vehicles, but the brothers are the directors of the company. How will such a situation be treated?
The share. We look at the share of how many shares do the deceased have, and that's what we'll distribute.
Okay.
To all the wives and all the children.
Yes.
The shares.
In equal measure?
No, more or less, yes.
Okay. Okay. I think we've come to the end of our session. And my last and final question is to all the attendees. If, to all our panelists, if the attendees were to take one action this week, what do you think it should be?
I can go first.
Yes.
For me, mine is very clear. Take action. Take stock of what you own. You might surprise yourself.
I think for me, Diana, is start. It's never too early to start. And I don't think this is for the people out there. It's for you. So start.
Start.
Yes.
Wow. So they've taken everything I could. Mine would be. Wow. This is hard. Okay, so let me combine the two. If you wake up every day and you plan for the day, why can't you plan for the end?
Interesting.
Yeah.
Okay. Ladies and gentlemen, we've heard from our panelists. So it's up to us to use this knowledge and put it into action. And the time to start you've had is today, not tomorrow after this session. Should you wish to set up a trust fund, please reach out to Zamara via phone, email, our social media pages, and we shall get back to you. And in case you need assistance preparing a will, please reach out to a qualified lawyer. The word there is qualified, not just any lawyer. And my key takeaway to you is that planning is not about fear. It's about organization. Ujipanga. Either ujipange ama upangwe. See you in the next one, and thank you for joining the call.